Now we're going to give everybody about a minute for some key takeaways. In other words, the key points you want the audience to remember from your segment. And we're going to do this in the order of the presentations. So we're going to start with Chris Spadea. Chris, some key takeaways?
Yeah, I think for me, on the pre-litigation, early litigation is these issues are becoming more germane and in some instances actually being formally required by the courts, such that you're really going to have to tackle the issues of expert opinions without full discovery and navigating all of those issues. I think the other real issue that I would take away from at least my portion is that I think Jeff just mentioned it, intersecting early at different points of the case, whether it be fact discovery, quickly, relatively lightweight, can have outsized impact later in the case in terms of being able to put on the most effective testimony. And I am seeing that happen a lot more as well, because I think my customers start to see the benefit of just a few hours of input, perhaps saving hundreds of hours of work down the road.
And thank you for that, Rob. Let's go to Kim Schenk. Some key takeaways, Kim?
Sure. So I would say putting on a great case at trial is important. Everything that Jeff talked about is absolutely important when you're taking this case to a jury or in front of a judge if it's a bench trial. But you won't get the chance to do that if your expert doesn't survive Daubert. So I think what Jeff and I both talked about is the fact that a lot of the work avoiding a Daubert or putting on a great trial presentation needs to happen much earlier in the case. And I think this has been a theme for all of us here today, is that there's things you need to be thinking about when you're hiring your experts. There's things you need to be thinking about when you're figuring out what exactly it is you want them to be testifying about, and when you're collecting the documents and evidence that the expert's going to rely on, and when you're putting together the expert report. All of those points in time and places in the case are times where you need to be thinking about Daubert and deposition. And then finally, I'd say using your expert as a resource during this phase of the case. It's something you can do in fact discovery, and it's also something that's really, really helpful in expert discovery.
Thank you, Kim. Rob Hutchins, did you have anything you wanted to add in the key takeaways?
Sure. I'll just reiterate what Chris, Kim, and Jeff just said about trying to get the damages team involved as early as possible, so you can leverage their technical expertise to build out the damages support for damages. Also, just add to on the apportionment side, apportionment continues to be a challenge. It's still evolving, but at the end of the day, despite the uncertainty, I think the objective for any royalty analysis or damage analysis should be to focus on the incremental value that the patent invention adds to the end product. That's the overarching objective in any analysis, and that certainly has not changed despite the challenges we're encountering with reliably apportioning a royalty base or a royalty rate.
Thank you, Rob. And finally, Jeff Kinrich, any final thoughts from you, please?
Sure. First, when you're thinking about trial, tie your witnesses together. Work on the link between liability, causation, and damages, and make sure that's there. And as part of that, I said this before, and perhaps my most important theme, tell a story. Make this make sense. It's not just a recitation of dry facts, or perhaps a dry recitation of facts. It's a story that you can motivate. And if you do that well through your witnesses, I think you will have a much better outcome.